defense clinic, where we have the opportunity to represent many people who are homeless in the community and have worked with these laws. I'm just really here to welcome these wonderful folks from the ACLU and thank them for coming to speak to us tonight and say hello.
All right, hi everyone. My name is Perry McInich. I'm a student here at the University of Colorado Law School. On behalf of our ACLU student group board of Colin Wolford, Aaron Pierce, Ben Hanmender, and Tag Mossholder, I just want to welcome all of you here tonight. And just start by saying how honored we are to host Nathan Woodliff-Stanley and Mark Silverstein of the Colorado ACLU. This is a very important topic to discuss, and I want to get right into it to allow us enough time to hear what they have to say. So let me introduce them. Nathan Woodliff-Stanley became Executive Director of the ACLU of Colorado in October 2012. Nathan is an ordained Unitarian Universalist minister who served for 8 years in social justice ministry at Jefferson Unitarian Church in Golden, Colorado, before joining the ACLU. He is a board member of the Interfaith Alliance of Colorado and chair of its Public Policy Commission. Before moving to Colorado in 2002, Nathan served for 10 years as the founding executive director of the Mississippi Center for Nonprofits in Jackson, Mississippi, a statewide association providing management support for charitable organizations. He has served on more than a dozen nonprofit boards over the past 30 years. Originally from Iowa, Nathan earned a BA from Swarthmore College and a master's degrees from Yale Divinity School and the Yale School of Management. Mark Silverstein is a 1989 graduate of the Illinois College of Law. He served for a year as a law clerk to Judge James Moran of the United States District Court for the Northern District of Illinois, and another year as law clerk for Judge Harry Gregerson of the Ninth Circuit Court of Appeals. In 1991, he began working as the staff attorney for the ACLU of Southern California in Los Angeles. Since 1996, he has worked as legal director of the ACLU of Colorado, where he oversees the ACLU's litigation in a wide variety of cases raising issues of civil liberties and constitutional rights. So just to get started, Nathan, what does the ACLU of Colorado mean when it uses the phrase criminalization of homelessness?
I will answer that. I wanted to just, before I do, I wanted to get a little bit of a sense of who's here in the group. If you could raise your hands, how many of you are here with the School of Law? And how many of you are here with the University of Colorado, including, other than the School of Law? Well, others see you. How many of you live in Boulder? And are there any people here who live outside of Boulder? Oh, there are some. Okay. So that gives me a sense of who's in the room. As Perry said, I've been at the ACLU of Colorado for about 3.5 years now. The very first national ACLU conference that I went to, I thought it was interesting that the theme of the conference was about the intersection between economic justice and civil liberties. The purpose of the ACLU is to uphold civil liberties for all people, and what that really means in practice most of the time is defending civil liberties for the people who are most at risk, who are most vulnerable to having those liberties violated. So, as you know, in the area of free speech, it's not speech that everybody's okay with that you have to defend. It's the unpopular speech. It's the same thing as you're looking at individual rights and civil liberties. It's the people who are not always most welcome in a community, the people who are most likely to have their liberties violated, that you have to defend the most if you're going to really defend civil liberties for everyone. And in many communities, one of those groups, one of the people who are often the most vulnerable, are people who are homeless, people who don't have many of the advantages that other people have in terms of something as basic as having a place to go, your own place to go at night. When we started really working more on economic justice issues, it led us right into all of this work about homelessness and the criminalization of homelessness. And we started using that phrase, criminalization of homelessness, because part of what we realized is that what was happening in communities all across Colorado is that communities that were, whether it was homeowners or business interests or whoever it was who were uncomfortable with the presence of people who are homeless, and said, we need to do something about it. The response of many communities has been to say, well, let's make the problem go away. Let's pass laws and ordinances that make it a crime to do many of the things that you have to do to survive if you're homeless, in hopes that the people who are homeless in our community will go somewhere else. In many cases, the somewhere else ended up being jails. So a very disproportionate number of people in Colorado jails are people who are homeless. But it also is this attempt to try to compete to see what communities could be the most hostile to people who are homeless so that they'll go somewhere else and not be here. And I hate to say it, but Boulder has been an active participant in that effort to try to be as unfriendly as possible to people who are homeless. There's an interesting study that was done recently by students at the University of Denver Law School. This report here called Too High a Price, What Criminalizing Homelessness Costs Colorado. There are a lot of costs. This incarceration has costs, the enforcement of ordinances has costs. But what they found is that there's over 350 anti-homeless ordinances in communities across Colorado. And they cover a wide range of things. There are anti-panhandling ordinances, things that make it illegal to ask for money, to ask for help. This is an area that we've worked on a lot at the ACLU of Colorado, and you'll hear some more about that, particularly from Mark. There are camping bans, and you know all about that here in Boulder because Boulder actually has issued more citations for violation of camping ban than all other communities in Colorado combined. In fact, almost twice as many as all other communities in Colorado combined. Boulder is the absolute worst offender of any community in Colorado in its use of camping ban to criminalize homelessness. There are sit-lie ordinances. We saw one that was just passed in Colorado Springs not that long ago, and in fact, there was a sit-in this weekend in protest. The perfect protest for a sit-lie ordinance is a sit-in, don't you think? Make it illegal to sit or lie down in public spaces. There are ordinances against sleeping in cars. I don't know if we have. There are places in the country that have made it illegal to share food in public places. There are obstruction laws. There are things like that don't seem necessarily at first like they're aimed at people who are homeless, but things like open container laws and outdoor smoking bans, things like this, which are often then disproportionately used to target people who are homeless. And something as basic as an open container law, I mean, if you have a home, you can go home, you can have a beer, it's not a problem. If you're an adult, no issue. But if you try to do the same thing and you don't have a home, you can end up in jail for the exact same thing that somebody else has perfect freedom to do. Things like public urination. And in fact, public urination, public defecation, you can end up on the sex offender registry for these offenses, which has enormous impact on the rest of your life, limiting where you can work, where you can live, all sorts of other limitations on your life. But what are you supposed to do? If you imagine yourself without a home, without a place to go at night, or even during the day, you have to sleep. Where are you going to sleep? You have to go to the bathroom. Where are you going to go? What you have to eat. How are you going to get the food to eat? I mean, the basic things you have to do just to survive, our communities are making criminal. And when you have, I mean, it's basically impossible to be homeless and to not break the law. And that's why we say it's criminalization of homelessness. There really is almost no way around it. If you don't have a home, you're going to end up breaking the law. And we see this. We see the fines and the fees, and then that leads to people being jailed for either directly or indirectly not being able to pay those fines. That has led the ACLU of Colorado into a whole area around debtors' prison practices, and we've had legislation on that. We will talk some more about that as well as we go through this time. But it's a constant struggle for people who are homeless. They're constantly told, move along, go somewhere else, The answer, what is never said is move along to where? Where are you supposed to go? Where is it okay to go? If you're on private space, you're trespassing. If you're on public space, you're violating, curfew laws or obstruction laws or sit-lie ordinances or whatever it is. In fact, there are a category of ordinances where the very offense is simply about being somewhere. Vagrancy and trespassing and loitering and curfew laws, where it's not even really about a crime other than your simple presence in the wrong place in the wrong time. And so, yes, I don't think it's too strong a term to talk about. A lot of communities object and they say, oh, we're not criminalizing homelessness, but we would argue, yes, they are, because if there's no way to be homeless without committing a crime, you've criminalized homelessness.
Right, and you've described a wide variety of ordinances that are used across the country and across Colorado. But in the courts, Mark, how are those ordinances actually playing out in municipal court, and how are poor and homeless people treated in municipal courts?
Well, one thing I can tell you about is a practice that we have been working on at the ACLU for the last couple of years, and we call it debtors' prisons. Most everyone knows that it's only in the old days that people could be sent to jail because they owed a debt, and we know that debtors' prisons were abolished in this country long ago. But we found that in Colorado courts, especially the municipal courts, debtors' prison practices were alive and well, and it was often the very poor or the homeless who were the victims. So how did this work? In municipal court, many offenses are punishable, are punished by a fine. But municipal court judges don't make an inquiry into a person's ability to pay the fine at the time the court is imposing it. They'll let people go on payment plans, but when payments are missed, what we saw 2 years ago was that municipal courts were issuing warrants just because somebody missed a payment. And some of those warrants were called pay or serve warrants. Here's how it worked. A given municipal court might say, okay, you have a $500 fine. We work that off at $50 a day. So if you miss your payment date on your fine, the pay or serve warrant instructs the police to arrest this defendant and get the $500 or lock the person up for 10 days in jail. We had to reach back about 45 years to Supreme Court precedent that dealt with situations like this. It was in the early 1970s that the Supreme Court had a case that said that when a court imposes a fine for an offense, it can't automatically convert that fine into a jail sentence simply because the person is too poor to pay. That was the law in the early 1970s, but somehow ordinances remained on the books in many municipalities that authorized courts to have defendants work off their fines at a daily rate. These pay or serve warrants or failure to pay warrants were issued without any inquiry into whether the failure to pay was because the defendant was too poor to pay. And what subsequent Supreme Court cases have said is that you can't jail someone for failing to obey a court order, like pay a fine, unless the person is capable of complying with that court order. And before someone can be sentenced to jail for non-payment, the court has to conduct an inquiry where the critical question is the person's ability to pay. That's been the Supreme Court law for several decades. Yet municipal courts were issuing these warrants saying lock the person up for 10 days or get the money without any inquiry into ability to pay. And truly indigent people, including homeless people, were being sucked up by these warrants, and they were going to jail simply because they were too poor to pay a fine. These sentences violated Supreme Court precedent. We brought this issue to the Colorado legislature 2 years ago, and legislation passed that outlawed failure to pay warrants, and the legislation mandated that the courts need to instruct defendants that if they can't pay, they can come to court and ask for a revision of the fine or a better payment plan. And it also prohibited courts from sentencing anyone to jail for failure to pay unless there was first a hearing for contempt of court. Contempt of court is willful failure to obey a court order. The court order is pay the money. Willful failure to pay means you got the money and you didn't pay. The court can't put you in jail unless it determines you've got the money and can't pay. That was the legislation 2 years ago. What we discovered since, as we looked, we monitored how are municipal courts complying with this. And we discovered that they have found a sneaky loophole. So what municipal courts started doing when they imposed a fine and when there was a payment plan, say pay $50 a month for 10 months, the municipal court said that every payment date was a court appearance. Court appearance was waived if you paid the money on time. But if you missed a payment and you didn't show up in court, a warrant issued. It was illegal to issue a warrant for failure to pay, and it was illegal to issue a warrant that said pay or serve. But they issued warrants for failure to appear. And these warrants for failure to appear had a bond set on them. So when an officer found the defendant and arrested the person, there was a bond. And the bond was the amount of the fine owed to the court. And so the arrest, of course, made friends and family and everybody try to raise the money to bail their person out of jail. And the court had the opportunity to take that money for payment. Or if no bond was posted, then it could be who knows how many days before the person went to court to talk about the payment plan and the missed payments. Some municipal courts meet once a week, some once a month. How long would someone have to stay in jail, held on failure to appear, waiting for the next court appearance? So right now, we are supporting a bill that's in the Colorado legislature that's seeking to plug this new loophole and to ban municipal courts from making the payment date the equivalent of a missed court appearance, so that these failure to appear warrants can't be issued. What we would really like to do is get municipal courts out of the business of using jail or the threat of jail as a means of coercing payments, especially coercing payments from people who can't pay. You know, private debt collectors, they can't threaten jail, they can't put you in jail. Private debt collectors, they can't even call you up too early in the morning or too late at night to ask you about the payment. So why do we let municipal courts do this?
Not supposed to.
So that's one of the things going on for homeless people in courts.
Aside from legislation targeting debtors' prisons, what are some other ways that we can address the issue locally?
Well, there's both locally and statewide. When we say statewide, another approach that we've taken on this, working with groups like Denver Homeless Out Loud and other, working with other partners and advocate groups. We've supported statewide legislation called the Right to Rest Act. It was introduced for the first time in 2015. It lost in committee by an 8-3 vote. It was reintroduced this year with a slightly weaker form of the bill. We took out some things that related to rights of action under the law, but what it still does is to prohibit some of these kinds of ordinances that criminalize homelessness. So things like things that prevent somebody from being able to sleep or rest, things that ban sleeping in cars even, which is another one that a lot of communities are using, so that even if you have a car, you can be arrested for sleeping in your own car in some places. Things like sharing food, panhandling ordinances, these sorts of things, so that so that there's a space created, so that you don't have this race to the bottom, where every community is trying to pass the worst possible ordinances to make people who are homeless go to another community. And this time there was a much more serious debate on it. It did end up losing in committee again by a 6-5 vote. We're hoping that.
Is that House or House property?
This was in the House Judiciary, and I think it's being taken more seriously. We're going to keep coming with this. We're going to keep trying to do this, because you can't just address it on a city-by-city basis, because there is this sort of competitive force. I mean, you have Denver is doing these sweeps of areas where people who are homeless have set up, temporary shelter, and they've been sweeping those away and then chasing them around the city, making, in a way that wasn't. There was a lot of publicity about an initial sweep that was done in Denver. What a lot of people don't realize is it was just the beginning of an ongoing process where in subsequent sweeps there was no notice given, there was no posting, there was, and they go through, confiscate a lot of the property of, and you're talking about people who don't have that much. I mean, this is a whole area unto itself, is this notion that if you don't have a home, if you're homeless, that you don't have the right to own possessions more than you can carry on your body. Because no one defines it that way, but that's actually, practically speaking, what happens. Even in shelters, you're often not allowed to carry more than a certain amount of your possessions into a shelter. That's one of the things among several that keeps people from wanting to go into shelters. Because if they can't take their stuff in, if they have to leave it outside, they don't know if it's still going to be there when they come back. And then you have these sweeps, and if they say you have to leave, anything you can't carry with you is going to get thrown into a dump truck, some of it's been cataloged. I mean, there was a sweep that was done in Denver last December, and ACLU did records requests to see if they had inventoried what had been taken, and what we found was no, there were no inventories of anything from that sweep. So they put in place some processes that were to, inventory materials, but there's a lot of problems still with that process. And again, it gets back to this question of why should it be, if anybody who's familiar with people who are homeless knows it's one of the most frequent complaints is this confiscation of property that happens, all of the time. So at the local level, certainly getting familiar with what your own community's form of this criminalization of homelessness is. Obviously in Boulder, one of the worst things is the camping ban. It's not the only thing, though. There are other ordinances. I mean, actually you're one of the few communities that I know of that is using these outdoor smoking bans as a way of targeting people who are homeless. And it's sold as an environmental measure, but it's used as an anti-homelessness measure. That's really what it's all about. And getting familiar with what's going on in your community, and then being advocates, speaking up, letting the city council know, talking about what's going on. And I know there are efforts from people here in this room that are working on communicating to the city council that this camping ban has to go. It's inexcusable that Boulder uses the camping ban so extensively. I think it's the DU study here found that in a 4-year period, there were over 1,700 citations under the camping ban in Boulder, and the vast majority of those are of people who are homeless. The police have been very aggressive. Now, there's a wide range in individual police. There's some people some police officers really don't even want to enforce the ordinance. But there are others who have been very aggressive about it, and they've arrested people because the way the law works, the camping ban works here in Boulder, is that it's not illegal you could lie on the ground in your clothes and not be violating the law. But if you have shelter, then you're camping. and now you're breaking the law. And that shelter can be as simple as just a little blanket. In fact, it could even be another piece of clothing that you're not wearing, but that you're just putting over you. That's shelter. Police have actually arrested people for sleeping under a tree because the tree was shelter, or for putting their head on a backpack because the backpack sheltered their head from the ground. I mean, now I think those two cases were actually thrown out by the court, but it shows you how aggressive the effort of the police sometimes is to define anything as being shelter. The ACLU of Colorado had a case in 2011. It was David Madison. It was a night when he had been turned away from the shelters. It was 11 degrees outside, and he was arrested for sleeping in a sleeping bag because the sleeping bag constituted illegal shelter, and he was violating the camping ban. If he would just lie on the ground in his clothing at 11 degrees, that would have been legal. But having a sleeping bag, he's breaking the law, and it turns him into a criminal. Then by using criminalization of homelessness as a tool against people who are homeless, one of the implications of that is they then have criminal records. That perpetuates the whole cycle of poverty, because you have a criminal record, then you can't get a job, you can't get certain services. It's a terrible, it does not do anything to actually address the underlying causes of homelessness. While the ACLU is not primarily a service organization, another thing you can do on the local level is to advocate for services that actually do address homelessness, things like housing and mental health services and things like public restrooms and maybe having locker facilities or things that actually help people who are homeless rather than something that simply turns it into a crime. What we don't want is communities to think that if you can just hide away people who are homeless by forcing them into another community, by putting them in jail, by forcing them into the most obscure shadows, and making it look like there's not a problem, that then they don't have to do anything. What's important is to recognize the advocacy from the community needs to be, these are people who have rights just like anyone else, who have personal stories just like anyone else. We can't treat people as if they're trash, and that's what is happening in a lot of Colorado communities.
And one thing that's become clear, especially after this DU study, is that every city has a different way of targeting the homeless population, but it's usually to that same end goal. And you've also mentioned this race to the bottom where cities try and kind of outdo each other on making the harshest laws they can possibly make. Does that kind of create an environment where you have the same problem you kind of had with your debtors prison efforts, where when you try and close one loophole, one opens up in a nearby city or in the same city? What have been your successes challenging these specific ordinances like panhandling and camping, and how do these issues still persist after the?
I will say, first of all, that's one of the reasons that you have to have some statewide solutions, like the Right to Rest Act, because you're not going to solve all of it just at a local by local level. But you have to keep working at that local level, and sometimes, and I think Mark's going to give an example of this, you can do something at a local level that has a ripple effect all across the state. We've been very successful, particularly after the Grand Junction decision, in affecting panhandling bans all around the state. But an example of a community that we've been working in a lot is also Colorado Springs, which I mentioned the sit-lie ordinance, but there's a lot more going on there as well. And I think Mark can say more about both what we did in Grand Junction and what's going on in Colorado Springs, and how you can actually make progress on some of these issues.
Colorado Springs, one of my favorite cities to talk about. So, we started looking at the Colorado Springs Municipal Court last summer, and we were looking at how Colorado Springs was enforcing its two panhandling ordinances. Colorado Springs' two panhandling ordinances were very much like panhandling ordinances in a number of cities. They outlawed panhandling in various ways, approaching someone and asking for money in certain places at certain times of the day. But they made an exception. And that exception was if you were just passively holding a sign asking for charity, that wasn't considered soliciting under the ordinance's definition. So people just holding a sign were not violating the panhandling ordinances. But what we discovered in looking at the citations that were actually issued in Colorado Springs and looking at what was going on in court is Colorado Springs was fitting a pattern of what we've discovered a lot of communities engage in with regards to visibly poor and homeless people. We struggled to find a name for it, but we started talking about extra statutory enforcement or enforcing laws that don't exist. What we saw was that police were writing hundreds and hundreds and hundreds of citations for panhandling, issuing them to people who were simply holding signs inviting charity. They were issuing hundreds of citations to people who were not violating the ordinances. And then what should be the fail-safe is the city prosecutor's office should take those citations and throw them out, because you can read right on it that the person was just holding a sign. But the city attorney's office prosecuted these citations, and then the municipal court was entering convictions. Most of these citations were issued under a panhandling ordinance that didn't provide for jail time. And so that meant that the defendants did not have a right to appointed counsel if they were indigent. And of course, the people who were dragged in for these bogus panhandling citations were indigent. Every branch of the Colorado Springs law enforcement agencies had a culpable role in railroading innocent people from citation to prosecution to conviction. Hundreds and hundreds and hundreds of them. We wrote to Colorado Springs about this, and to their credit, they actually agreed to dismiss all of the pending tickets and to vacate the sentences that were not yet completed, the fines that hadn't been paid, or if people were put on probation. But here's the next thing we found. The municipal court was sentencing people for non-jailable offenses to jail when the people were too poor to pay their fines. Now, the debtor's prison issue I told you about was one where a court needs to hold an indigency hearing and determine whether the failure to pay was due to indigence. And of course, if it was, then you can't sentence someone to jail. Colorado Springs skipped that step, or they did it backwards. The sentencing would go like this. Okay, panhandling, that's a $500 fine. Can you pay? No, Judge, I'm homeless, I'm unemployed. Okay, well, we'll convert that to jail at $50 a day. The court was sentencing people to jail for failure to pay because they were indigent, not in spite of their indigence, but because of their indigence. And they were doing this. We found over 800 of these sentences, and probably 3/4 of the people were in for, they were for citations for probably the kinds of offenses that we're calling criminalization of the homeless: panhandling, trespass, violation of park hours, smoking cigarettes in the park, pedestrian and roadway, also called jaywalking. Hundreds and hundreds and hundreds of these. We have told Colorado Springs that they have to stop converting jail sentences, fines into jail sentences, and we've also told them that they need to compensate everyone who was illegally jailed under this practice. And we are still negotiating that. But I think, you know, this is the tip of the iceberg. The fact that every branch of the criminal justice enforcement in Colorado Springs was doing this was nobody noticed, or nobody cared, or it was just homeless people anyway. we have seen the same kind of extra statutory enforcement with other kinds of ordinances and in other cities. And I bet we are just scratching the surface.
You also targeted panhandling laws in Grand Junction. Can you tell us about that case?
Sure. Grand Junction wrote to us in early 2014, and is that what it was? Yeah, 2014. And they were about to enact an ordinance that they called a prohibition of aggressive panhandling. And they asked us at the ACLU whether we thought there were any problems with it. We wrote them immediately and told them that there were very serious constitutional problems with it and they should not enact the ordinance. At the next meeting of the city council, they unanimously adopted the ordinance. This ordinance, like many panhandling ordinances, this purports to be a prohibition of aggressive panhandling, but it includes within its prohibitions much peaceful, polite, non-intrusive requests for charity that don't invade anyone's rights. We challenged this ordinance. As soon as we challenged it, Grand Junction amended the ordinance, narrowed it, and adopted a city council resolution that expressed their resentment at the ACLU. We continued with the challenge, and there was a year of litigation. At the time we filed this challenge, I'll give you a little bit of legal background since we are at a law school. Courts have long recognized that requests for charity, that's expression that's protected by the First Amendment. And after initial resistance, courts also have recognized that even when it's an individual poor person asking for charity for themselves, that also is protected by the First Amendment. Courts began to recognize that the old laws that just banned any begging or soliciting in public places were no good. They violated the First Amendment. So that's when courts started trying, or cities started trying to adopt panhandling ordinances that they said they were trying to separate the non-intrusive, peaceful requests for charity from the really aggressive stuff that invaded people's rights. We said that these laws were content-based restrictions of expression. A content-based restriction of expression is subject to the strictest level of judicial scrutiny, and those are, it's almost never that such an ordinance could be upheld. It's a content-based ordinance because an ordinance, like in Grand Junction, prohibits asking for money at a bus stop. But if instead you ask for directions, or you ask, where can I catch a cab, that's not prohibited. So obviously, it's a restriction on the kind of message you're sending with your request. But the cities, and there were many courts that backed them up, said, no, this is not content-based because we're not discriminating. We don't care if you're asking for money for environmental causes. We don't care if you're asking for money for the Blue Cross. We don't care if you're asking money for yourself. Whatever the content of your charitable request, we don't care. It's content neutral and is therefore subject to an intermediate level of judicial scrutiny, and many courts had upheld panhandling ordinances that claimed to simply regulate the time, place, or manner of panhandling. And one of the things that the city said is an ordinance is not content-based unless the city has adopted a regulation of speech because of disagreement with its message. And the city says, we didn't adopt this because of disagreement with the message. We don't care what you say. We just want to protect public safety. But what Judge Arguello said was that she said that she believes that Grand Junction did adopt an ordinance regulating speech because of its message. And here's what she said. This court believes that panhandling carries a message. Often a request for money conveys conditions of poverty, homelessness, and unemployment, as well as a lack of access to medical care, reentry services for persons convicted of crimes, and mental health support for veterans. The city's attempt to regulate this message is an attempt to restrain the expression of conditions of poverty to other citizens. So she said that this was an ordinance that was based on the content of the message, subject to the highest level of judicial scrutiny, and that's why most of the provisions were held unconstitutional. And it was a major victory in the sense that I think every panhandling ordinance in Colorado has got a legal cloud hanging over it, because almost every one is regulating speech on the basis of content in violation of the First Amendment. And after this decision last fall, Denver, Boulder, Colorado Springs, a number of communities have already revised their panhandling ordinances. And the provisions that remain that we have not objected to are ones that say it's illegal to go up and like put your hands on someone while you're asking for money, or it's illegal to actually obstruct someone's passage on the sidewalk and not let them get by while you're asking for money, or it's illegal to put someone in reasonable fear of receiving a battery while asking for money. That's truly aggressive panhandling. Those are crimes independent of the request for charity, and those provisions can stand. But the majority of panhandling ordinances violate the First Amendment.
Great. At this point, I'd like to open it up to questions if anybody has any particular questions.
I've got a couple of them, if you don't mind. How do these panhandling laws differ from the old vagrancy laws that used to be in place throughout the country? And the other is back in the 90s, my sister's a psychiatrist, and back in the 90s, she became aware of a study that was done that close to 70% of the homeless at that point in time were vets, and they were not being given medical treatment or any kind of help whatsoever while on the streets. And are there any new studies? Because to me this to do this to people who fought for our country and have I'm sorry, just go ahead.
This is the reality of it, because I don't know the statistics on this, and I don't know if there's been follow-up studies specifically about the numbers, but we know that there is a substantial portion of the population of people who are homeless who are veterans.
A lot of them were not vets
Yes,
back then.
and who may have PTSD, who may have other conditions, or just who were never able to have the reintegration into society that they should have had the opportunity to do. And instead of being recognized and celebrated for what they did, we're just forgotten, marginalized. Because it's this notion that people should ever be treated as less than people, and yet we somehow do this. We somehow do this, and the demand that's often in the name of property values or tourism or whatever it is, community quality of life, whatever it is that are the excuses that are then used to basically treat some people's lives as if they're throwaway lives, is just not okay. And it does happen. I don't know the numbers as far as veterans, but we know it's a significant portion of the population that's homeless. What was the first question that you asked?
Vagrancy.
The vagrancy?
Yes, these are the the Supreme Court said that the vagrancy laws that simply made it a crime to be a poor person in public violated the Constitution. And so I think that the begging ordinances are the next generation of vagrancy ordinances, loitering and panhandling.
According to this report, there are still 7 communities in Colorado that have vagrancy laws, even though they've been found unconstitutional. I mean, they're not the laws that are primarily used now. There are loitering laws that are still used. I think Pueblo, that's the primary thing that they arrest people for is loitering. There's, as you said, there's different ordinances that get used in different places, but they all have essentially the same effect. And I think that statement by the judge is really important in the Grand Junction case, is really important to keep in mind, because what she's saying is that the message around panhandling is not just an individual message. It's a message about the social condition that is creating homelessness. It's a message about poverty. It's a message about homelessness on the whole. And if communities are allowed to successfully just whitewash homelessness to make it appear to go away, then people won't get that message. And yes, there are people who feel uncomfortable seeing people who are homeless. There are people who are uncomfortable being approached to, or even walking by somebody who's holding a sign asking for money. But maybe we need to feel that discomfort. If our communities try to hide us from discomfort, then we won't do the things that we need to do to actually address these issues. And that's what we're seeing happening. Is communities saying, oh, there are people who don't like that, so we want to make it go away. But making it go away by the means of criminalization of homelessness is not the way to do it. If we want to actually be a society that doesn't have problems of homelessness, we have to address it in a very different way. We have to address things like housing and services in a substantial way. And communities will say, oh yes, we're doing that, and they often are to an extent, but it clearly isn't enough. And in fact, Colorado is one of the worst states in the whole country for affordable housing. We're near the bottom on that. So there are clearly issues that need to be addressed that may not be pure civil liberties issues, but if they aren't addressed, it ends up becoming civil rights and civil liberties issues in the way that we see here. Thank you.
Did you guys do the Fort Collins thing?
Yes.
Could you talk more about that?
Fort Collins was another city that was engaging in extra statutory enforcement of its panhandling ordinance. Its panhandling ordinance also made an exception for people who were simply passively holding a sign, yet our study showed that at least 2/3 of the citations issued for panhandling were issued to people who were not violating the panhandling ordinance. So we filed a lawsuit at the beginning of last year that challenged not only the constitutionality of the ordinance, but we also challenged the practice of enforcing the ordinance against people who were not violating it. The judge who heard the case had been on our legal panel before he got on the bench. And the biggest issue in the case, the defendants wanted to do anything but talk about the merits of the First Amendment issues. So they tried their best to disqualify the judge because he'd previously been involved with the ACLU, but they failed to do that. And after they failed to force the judge to recuse himself, they quickly repealed their ordinance and then settled with us within a couple months.
Sure.
Thanks. I want to first thank you for both the work you do and for making it accessible through things like your interviews with Colorado Public Radio and press. Those of us who experience homelessness sometimes have a hard time hearing the news about us. And when I've been homeless 21 years continuously as an adult or as a youth, when I hear you give an interview on Colorado Public Radio, I am cheering. And believe me, when I'm talking to people, in parking lots or outdoors who are experiencing homelessness, I'm saying, did you hear what happened? Did you hear what the ACLU did? So you guys are rocking. I'm really grateful. I heard on the radio today that 4 people were arrested in protesting in Colorado Springs.
Yes.
Okay, and I'm curious how this works up to the 10th Circuit Court of Appeals. Do you expect this to happen? And how long till we get something nationwide like a SCOTUS ruling?
So the last part?
How long till we have some
How long till
Supreme
we
Court-
Ruth Bader?
I'll tell you something about the Supreme Court. Like, I got interested in being a lawyer back in the late 60s, early 70s. I'd be reading all these great decisions from the Warren Court, all these progressive decisions, and it looked like, oh, law, like what a great tool for social change. And then by the time I went to law school, which was a lot later, I felt like it was a bait and switch. And so there's all these conservative, horrible decisions narrowing and narrowing and narrowing sometimes the simple ways you can just go to court and win a case. And so this opening in the Supreme Court now, like, I start dreaming of, oh my God, are we gonna have a court where some of those 5-4 decisions that, you know, have ruined my life are now gonna be reversed?
Yeah.
But I'll tell you, one of the things that's happened that we've learned at the ACLU over the years is that we're not relying just on the legal precedents and just on the Supreme Court. We don't rely just on, oh, well, we can just file a lawsuit and then, you know, a judge will rule and everything will be fine. So, you know, the ACLU has hired a lot of people, professionals that are not lawyers. We have people that work in the legislature. We have communication specialists. We have people that work on advocacy that's outside the courtroom. And, you know, we've tried to use all of those means. Sometimes something might not be illegal, but it can still be, with enough research and with getting the word out, it can be outrageous enough that people are going to revolt against it. People hate abuses of power, even if they're legal abuses of power. And so we can win victories outside the courtroom that we might not yet be able to win in court.
Yeah.
And also the courts, they have an ear to the ground. And the courts gradually can shift their doctrines as public opinion shifts. And you know, that sit-lie ordinance in Colorado Springs, people were arrested, 4 people were cited. They actually just got notices to appear. 20-some years ago, the 9th Circuit Court of Appeals upheld in a 2-to-1 decision a similar ordinance. And that's been the model for other cities that have adopted similar ordinances. 20 years later, it might not come out the same way. And you know, 20 years ago, I don't know if there were people having demonstrations when the city passed a sit-lie ordinance, but that's what we had on Saturday in Colorado Springs. So that can help change.
Yeah, I wanna reinforce that, because if you're asking about the Supreme Court, first of all, I mean, we're nonpartisan, we can't tell you who to vote for, but being engaged in the political process has huge implications, and who gets appointed, because it won't just be one, there will probably be multiple Supreme Court appointees by whoever is the next president, and you know, process through whoever is in the next Senate. So it does matter, you know, to get engaged with that. And then you're getting involved in other ways. I mean, this is not, you know, the sort of thing that's going on in Colorado Springs right now with, you know, on the sit-lie ordinance. That's not all traditional, you know, ACLU methodology, but being able to engage in more ways, being active here. Yes, if we have an opportunity to legally challenge something, and I know there are people here asking some of the same questions, how can, you know, is there an avenue to legally challenge these things? We didn't win the David Madison, you know, case here against the Boulder camping ban, but that doesn't mean that there isn't an avenue. Maybe the circumstances, you know, will change. I mean, there was the Department of Justice issued a court filing in a Boise, Idaho case last year where they called criminalization of homelessness through bans on outdoor sleeping both unconstitutional and counterproductive. Having something like that issued by the Department of Justice could be helpful, perhaps, in in a future case, although the grounds that they cite are basically the same grounds that we lost on.
Same argument we made.
Same argument we made,
We made it
but
too
didn't
early.
win on. So maybe there'll be an avenue to, where the legal picture will change enough to win. But even apart from that, you can, with enough pressure, change. The city council has the power to repeal the camping ban. It doesn't have to be overturned by a court case. They can just do it. And if communities say enough to their own elected officials, we can change this. It can be changed through those means, through communications and organizing and policy work. I don't know who raised their hand first. Did you?
On a similar note, and that's a great segue actually to my question. From the incidents you've described, you indicate that law enforcement is probably a larger dimension of this than just the legislative process. And I'm wondering if the ACLU has the resources or the ability to put any momentum behind what I think they support in terms of police review boards and transparency of operation, which would accord with what you've just said of allowing the people of the community, for good or bad, to know what their police force is doing, and if they do think it's bad, to be able to curtail it at a local level.
Well, we've certainly supported police review boards, civilian review of police.
But we've been trying to get one in Boulder forever. How do you make that happen?
Again, it's through advocacy. I mean, it's not like you can have a court case that forces that to happen. So it has to be, that has to be a matter of local advocacy, and so calling it to attention in the media, having meetings like this, I know that local ACLU activists for a long time have been calling for a real independent review board. I mean, there is a police review body here, but it's not independent. I mean, it isn't serving the purpose that it should serve. So, yeah, I mean, it's something that it needs to be a fairly wide community effort to demand that in order to have it happen. I mean, that's part of the reason that we've been moving in the direction of communications and field work and mobilizing and advocacy work for the ACLU is because there are so many issues that's the only way we're going to be effective, that we have to do that. But again, I encourage you to raise that point locally.
You guys might mention the Hillard Heinz report that just came out about that.
Yes, there was a report that was done. That was actually spurred by, and interestingly, there is an intersection, again, between economic justice and racial justice issues. Boulder, again, in spite of the progressive reputation of the community, did particularly poorly in a USA Today study that was looking at arrest rates by race. And it was in response to that, I believe, that the Heinz report was done. And it recommends, among other things, that there actually be an independent review board. It also recommends data collection on arrests by race. I think it's important to do these sorts of things, to have, if we don't know what's happening, if we don't have data. This is an example in Boulder, in Denver, for example. Denver has a camping ban too. They don't tend to give very many citations for the camping ban. They don't want to have the statistics as what Boulder has. But what they're doing, because if they did cite somebody under the camping ban in Denver, number one, there's a requirement to connect to services, and they don't want to bother with that, so they don't want to actually have to go through that process with a citation. And secondly, then there are statistics about it, and they know that we'll pull records requests and find out how many citations that there were. But what they're doing instead is they're telling people to move along, and using the camping ban as the move along reason. Like, you're violating the camping ban, move, go somewhere else. They never say where, but just move, go somewhere else. And that's a use of the camping ban, even though it's never going to show up in data or statistics. And so it's just an example of why being able to track what's going on is a piece of how you also can bring change. But that report is one worth looking at. I will say that part of the response on the racial bias claim is that the numbers are so small that the African American population, for example, is so small in Boulder, it's less than 1%, of the population. So the statistics don't mean anything because it's too small a sample, and therefore there is no racial bias problem in Boulder. And I find myself wondering if the African American population is that small, how is that an indication that there's not a racial bias problem? Why is that the case in the first place in Boulder? But that's a separate set of issues. These issues all connect with each other, though.
I asked this question at a recent Boulder Rights Watch meeting, and I'm curious your thoughts on if the city council here were to repeal the camping ban. Do you think there'd be all these tents and people sleeping in sleeping bags in parks, and the trash problem that may or may not come with it, and bathroom usage? And do you think that that's what would happen here?
I mean, I doubt it. I think there are elements of the concern that could probably be addressed with ordinances or laws other than a full-out, camping ban. There are communities that have addressed. I mean, there's some places. For example, I know there's some West Coast cities that have designated areas where people can camp, but they just can't be permanent encampments. They have to take them up at certain times. There are different ways of addressing some of those concerns. What I would say is, first of all, they should look at some of the more humane ways of addressing the things that are real concerns. I mean, there shouldn't be a difference. I mean, if it's legal to lie on the ground without a blanket, there's no different environmental impact from lying on the ground with a blanket. I mean, that's not a, there's really no justification for that type of definition of camping.
That seems to be a blanket statement.
That's good.
I'm sorry.
But the other thing I would say is that to the extent that did happen,
yes,
to the extent that there were, what that is that's the thing that the judge was talking about. That's the general speech about the underlying problem that will make people say, oh, we need to actually do something substantive here instead of trying to hide people away. And so it's not all bad, even if there are, visible homelessness is not, that's better than invisible homelessness that no one will do anything about, if that makes sense.
Yeah, it does. So the way I understand it is, I as a housed person, I have to sit with whatever my discomfort is.
Mm-hmm.
And that discomfort would then presumably, hopefully, prompt me to act or not act or feel something. But what I'm trying to understand is, in your work, is it the assumption then that in a repeal of a camping ban, that there would then, these things could potentially happen, and that's what a city would look like to you, and potentially?
It's hard to know, but I will say this. I mean, there are plenty of communities in Colorado that don't have camping bans, and they're not covered with tents and people sleeping on the ground.
Okay.
So it's actually probably not the case that it would be what people are. I'm sure people's imagination and fear is worse than what the reality would be.
Sure.
But it's hard to know because, I mean, how do you say what would it be if it's not the way it is? That's always difficult.
When you say more humane practice, is that what people refer to as an encampment? Or is there something else as by way of best practice?
I think more humane means not using police and courts as a way to address problems of visible poverty and homelessness.
Yeah.
Was there, you referenced something in California, was it? I'm asking because I'm agreeing with everything you're saying. I'm just trying to figure out a way, in the absence of the city council that's saying we're gonna repeal the camping ban, so then what's the next thing? What's our next step as advocates or Boulder Rights Watch, or what are we gonna do with that?
Well, it's probably the next step is to to address things like affordable housing and yeah.
Well, I can speak to that, actually. We had, at the previous meeting at the Boulder Rights Watch, our new city councilman, Aaron Brockett, showed up and basically brought up the same issue that you did and asked for some positive recommendations just to help them out, so that when people ask that great question, we could say, here's some possible answers. So, yeah, my name is Maury Bean, I'm an architect, and so knowing the whole game, I basically put in a pre-application for an intentional community at South Belmont Park at the recommendation of our planning board director. And as you can expect, about 2 weeks later, I got a note back from the planner saying, sorry, you can't do it in Belmont Park.
Excuse me, I think there were some more questions to ask of us. Maybe you guys could have your
Yeah.
conversation.
There's a question that's been back here for a long time. I wanted to make sure that, yeah.
Kind of along the lines of what a previous questioner asked, and you all may have tried this or be doing this already, but I'm curious on your thoughts in terms of, as opposed to civilian oversight board side, actually looking at the other side of the coin in terms of, strategy for combating these practices. Has there been any thoughts about, going to a given police department and speaking the true police language in terms of crime stats? You go to the police and you target the police that don't like doing this, consider it a waste of time, and maybe using statistics and police terminology to show that this is actually worse for community safety because the police are issuing over 1,000 citations as opposed to more serious crime.
I spoke to the Colorado Springs police chief and I said, how could it be that your officers wrote 800 tickets to homeless people who weren't violating the ordinances? He says, I don't know.
No, I mean certainly communication with, where there are cooperative, people who are cooperative within police departments, we want to communicate with them. It's not, we're not like determined to have an adversarial relationship, or it doesn't have to be. And there certainly are people in the, that just as there are, sometimes it crosses political lines where you have people who are worried about the cost of incarceration who are actually willing to act on some anti-incarceration measures for different reasons. This does happen, we saw people who were opposed, conservative legislators who were opposed to the sit-lie ordinance because they didn't want the government telling them where to sit. And it's worth looking at where can we find allies in any community, and we could do that. We also encourage local communities to do the same thing.
I think we can take maybe one more question and then closing remarks.
Here? Yeah, you had your hand raised.
Yeah, thanks. I remember a study or two in Colorado Springs, maybe last year, about discharge of vets with PTSD from, I guess it's Fort Carson, but anyway.
One Pulitzer.
What?
The journalist won a Pulitzer Prize for that.
Okay. Yeah. And instead of treating people with PTSD, they're giving them bad conduct or less than honorable discharges that don't entitle them to VA benefits. And I'm wondering if that's some of what's happening in Colorado Springs, that people are getting turned out there who ought to have mental health services and ought to have it on VA. And that could be something, even a project to get lawyers to challenge less than honorable discharges. Maybe.
Certainly could be a portion of the population there, certainly.
Certainly overall, and this goes back decades to when there was a large deinstitutionalization, in mental health. It led to, and of course at the time there were really horrible conditions in some of the mental hospitals. It was seen as a progressive thing to say, let's get people out of these institutions. And then there were all these promises of community mental health services that never happened. And what we ended up instead was with a significant number of people with mental illnesses who became homeless. And then that ended up leading to people getting arrested, and now our criminal justice system has become our default system for mental health, which is just wrong. And in fact, it re-traumatizes people. If somebody has PTSD, the experiences they go through in the criminal justice system is only going to make that worse. And so, yes, there's a whole set of issues there, and that's an interesting one that you raise, but there's also a broader issue around mental health that, again, if we're going to actually deal with the underlying issues, the substantive issues, we have to deal with that. We can't just say, let's hide homelessness by essentially making it illegal. All right.
Yeah, thank you so much for joining us. ACLU materials so you can know where to go next.
Yeah, actually, could I'd like to introduce to you our field coordinator. We hired Alejandra Garza in September, and part of her job is to work with communities all across the state and people who want to volunteer for the ACLU, who want to be activists for the ACLU. Do you want to say a little bit about what you're doing and
Yes.
how people can connect if they want to?
Yes, no, we're so thankful for all of you to come out, for coming out this evening and joining us. And we really are looking at ways that we can channel the enthusiasm and all of your talents on this issue as well as other issues that the ACLU works on. What I really respect about the ACLU is love us or hate us, you respect us because you know we work hard and we really believe in the right side of the civil rights battle that so many issues and so many communities face. So we would like to ask you to join us. In fact, I have a couple of success stories. Trisha, where are you? Trisha left. Trisha is a volunteer that I met here in Boulder, and last week she came and testified for a bill that we supported at the state capitol, at the state legislature. It was a notario bill, and she spoke with her experience as an attorney. That was valuable. We're also working with TAG. Where are you? TAG and I were talking about next year working with some students to prepare for the legislative session and then work on legislative issues as one of your projects through the year. If you come volunteer for us, I'm not going to give you a stack of papers to fold. I'm not going to give you envelopes to stamp. I'm going to put you to work on things that we all care about because we have so many issues that you can participate on, and we would be so fortunate to have you as our allies on this. Mark was right. There are some things we cannot find a legal strategy for. Some things that we cannot craft a bill for. John is a genius at communications, and he comes up with great strategies, and in field, we take those strategies and we put them into practice in communities across the state. I've been working in Colorado Springs, I've been working in Grand Junction, and across Colorado, and I really would like to take all of your voices with us so that you could help us and make this place a much fairer state for all of us. So thank you again for coming out, and we have some forms at the entrance. You can pick how much time you wanted to vote, what do you want to do, let us know, and we'd be happy to have you, so thank you again.